Just to finish Senator Blumenthal's point, I hope you realize how ridiculous the four of you look. Spouting these preposterous, canned answers in a forum in which A, you're supposed to tell the truth, and B, you're supposed to demonstrate the judicial capacity to make independent, factual decisions in hard cases. If you can't even sit here and say that Joe Biden won that election or that the Capitol was attacked, what's left? What's left if a hard case comes your way as a judge, and let's say the Trump administration is bearing down on that? Why would we ever believe that you would give the litigants a fair hearing and a fair decision if the executive branch was leaning in on you when we can't get a reasonable answer out of any of you with the executive branch leaning in on you to give these ridiculous answers today? Just to finish Senator Blumenthal's point, I hope you realize how ridiculous the four of you look. Spouting these preposterous, canned answers in a forum in which A, you're supposed to tell the truth, and B, you're supposed to demonstrate the judicial capacity to make independent, factual decisions in hard cases. If you can't even sit here and say that Joe Biden won that election or that the Capitol was attacked, what's left? What's left if a hard case comes your way as a judge, and let's say the Trump administration is bearing down on that? Why would we ever believe that you would give the litigants a fair hearing and a fair decision if the executive branch was leaning in on you when we can't get a reasonable answer out of any of you with the executive branch leaning in on you to give these ridiculous answers today? I'm really sorry to have to go through this and that you have to go through this. But it would be nice if you could tell your executive branch handlers, for instance, Ms. Clark, I'm supported by Lindsey Graham. He's a friend of President Trump. He's the second senior person on the Republican side in the Judiciary Committee. He's likely to be the next Judiciary Committee chair. I think I'll be okay. I don't need to make myself ridiculous at your direction. It'd be great if you could have said that. It would be great if your answers were simple and honest here today. It's really disappointing. Let me ask a different question, a legal question. A judge, you want to be judges. A judge gets a threat to the judge's life or to the judge's family. Can you imagine a scenario in which liability may attach to individuals beyond the utterer of that threat? Ms. Clark?
Senator, as a prosecutor, there are instances where there's some responsibility that is assigned to someone who is not the utterer of a threat to an individual. And so to answer your question, yes, I can imagine.
Do you agree?
Yes, Senator, and if confirmed to the bench, I would follow all Supreme Court precedent and Ninth Circuit precedent.
Mr. Rick, you agree?
Yes, Senator, I would agree with that.
I don't know that I care what you think, Ms. Westerkamp, because you're going to international trade and you're probably not going to see much of this, but do you agree?
Yes, Senator.
Yeah, and those doctrines that would provide the legal basis for investigation in those scenarios would include doctrines like, name one, Ms. Clark.
Senator, doctrines that are, if someone is essentially carrying out
solicitation, would that be
Yes.
one? Solicitation of a
Yes.
threat?
yes,
Or a conspiracy out of which the threat emerged, would that be another one?
yes,
Yes. How about, and it's the product of an enterprise under the racketeering statutes. Would that also be another way that liability could extend beyond the utterer?
That is correct, Senator.
Can you think of any others, Ms. Lane, where liability extends beyond the utterer of the threat? What are some of the legal theories that would support that kind of investigation and prosecution?
Senator, the doctrines you mentioned, I would agree with, and I would just look always to the federal law and federal statutes guiding that.
Mr. Recchi?
Senator, I would agree with that. I think you covered the major ones: conspiracy, RICO. There may be other avenues of potential legal liability, but I think you covered the three big ones in that scenario.
Ms. Westerkamp, you agree?
Senator, I'm not aware if there are any more. With my practice before the Court of International Trade and Court of Federal Claims, it doesn't touch on criminal law.
So here's why I asked you these questions. I asked you these questions because right now federal judges are under the worst shadow of physical threat in my lifetime and perhaps in the history of this country. And in responding to those threats, we have the United States Marshal Service, which reports to the Department of Justice. And I have now over a dozen times asked the Marshal Service, will you investigate behind the utterer of a threat if the evidence justifies it? That's a super easy question. The answer is, yeah, of course we will. They won't answer that. They won't answer that. And I point this out because judges across the country need to pay attention to the fact that the Marshal Service won't confirm that it will investigate behind the utterer of a threat if the evidence supports that. And why would that be the case? That would be the case because when you get behind the utterer of a lot of these threats, you run into right-wing conspiracies. And this MAGA Department of Justice would rather not go there. And so they leave judges exposed with investigations in which they aren't doing investigative 101 work that you've all identified as plausible legal theories. And we need to fix that. We need to fix that.
All right, let's step directly back into the blast radius of this Senate Judiciary Committee hearing, because if you thought the previous round of questioning was tense, Senator Sheldon Whitehouse of Rhode Island just took the entire room and threw it into a high-voltage centrifugal separator. What you're looking at here is an absolute un-sanitized execution of congressional oversight that skips right past the polite, legalistic dance and goes straight for the throat of the modern political machine. Whitehouse isn't just mildly annoyed, he is visibly, deeply disgusted by what he views as a systemic degradation of the federal judiciary. Look at how he opens his time. He doesn't even introduce a new topic yet. He hitches his wagon directly to the end of Senator Blumenthal's clock and addresses the 4 nominees sitting at the witness table with staggering candor. He tells them flat out, "I hope you realize how ridiculous the 4 of you look spouting these preposterous canned answers." Let's pause for a crucial educational look at why a seasoned senator would use such aggressive language in a formal confirmation forum. Whitehouse is highlighting a fundamental paradox. A confirmation hearing has 2 sacred constitutional purposes. First, the nominee must tell the absolute truth under oath. Second, they must demonstrate the intellectual and psychological capacity to make independent, hard, factual decisions based on evidence, even when the entire world is screaming at them. Whitehouse's argument is brilliantly simple. If these nominees lack the spine to look at a sitting senator and state the plain, universally acknowledged historical fact that Joe Biden won the 2020 election, or that a violent mob physically breached the Capitol on January 6th, how on earth can the American public trust them to stand firm when a truly difficult, high-stakes constitutional crisis lands on their bench? He frames this as a terrifying diagnostic test for the future. He paints a scenario where a future executive administration is bearing down on their courtroom, leaning on them to rule a certain way in partisan case. He asks with intense friction, why would we ever believe that you would give the litigants a fair hearing and a fair decision if the executive branch was leaning in on you to give these ridiculous answers today? This is the core insight of the entire interaction. Whitehouse is pulling back the curtain on the White House handler system, openly mocking the nominees for being so terrified of their political handlers that they would willingly sacrifice their own professional dignity on live television just to survive the gauntlet. He even offers a biting piece of practical advice to one of the nominees, Miss Clark, pointing out that because she has the backing of a senior Republican heavyweight like Lindsey Graham, she didn't even need to play these ridiculous linguistic games to get confirmed. She could have just been honest, but instead, she chose the script. Now watch the classic procedural pivot Whitehouse executes at the 2-minute mark. He shifts from a political diagnostic test to an advanced seminar on criminal law. He asks the nominees to imagine a highly relevant real-world scenario. A federal judge receives a direct, explicit threat to their life or the lives of their family members. He asks a precise legal question. Can you imagine a scenario in which liability may attach to individuals beyond the utterer of that threat? Because this is a standard criminal law concept, the nominees' handlers haven't forbidden them from answering it. So, one by one, they fall right into line. Miss Clark confirms that, yes, as a prosecutor, she can absolutely imagine scenarios where third parties bear criminal responsibility. Whitehouse pushes her to name the specific legal doctrines that allow investigators to look past the person who typed or screamed the threat. She tentatively offers solicitation. Whitehouse nods and feeds her the next one, or a conspiracy out of which the threat emerged. She agrees. He drops the ultimate prosecutor's tool, and it's the product of an enterprise under the racketeering statutes, RICO. She agrees again. He goes down the line to Mississippi Lane and Mr. Ricky, and they all nod along, confirming that conspiracy, solicitation, and RICO are investigative 101 doctrines that allow law enforcement to track down the network, the funders, and the instigators behind a crime, rather than just arresting the low-level actor who delivered the message. Even Kara Westerkamp, the international trade nominee, whom Whitehouse hilariously brushes off by saying, "I don't know that I care what you think, because you're going to international trade," chimes in to acknowledge the framework. But look at the massive trap Whitehouse has just sprung on the record. He didn't ask these technical legal questions just to quiz them on their law school textbooks. He did it to expose a deeply alarming institutional cover-up happening within the current Department of Justice. He reveals that right now, federal judges across the United States are living under the absolute worst shadow of physical violence and death threats in modern American history. To combat this, the country relies on the United States Marshal Service, an agency that reports directly to the Department of Justice. Whitehouse drops an un-sanitized bombshell. He has personally asked the leadership of the U.S. Marshal Service over a dozen times a beautifully simple, nonpartisan question. If someone threatens a federal judge, will you investigate the people, organizations, or networks standing behind the person who made the threat if the evidence justifies it? And what is the Marshal Service's answer? They refuse to say yes. They completely stonewall Congress. Whitehouse points out the terrifying hypocrisy of this breakdown. A panel of heavily coached judicial nominees can sit at a table and instantly identify conspiracy and RICO as basic, standard legal theories for an investigation. Yet the literal law enforcement agency tasked with protecting those judges' lives refuses to confirm under oath that they will actually execute that basic investigative work. Why would a federal law enforcement agency refuse to confirm that they will investigate behind the scenes of a death threat? Whitehouse states the raw, deeply partisan reality of the 2026 landscape, because when investigators actually start pulling on the threads of these modern threats against judges, the trail directly leads back to highly organized, politically connected right-wing conspiracy networks and MAGA line groups. Whitehouse boldly charges that the current Department of Justice would rather leave its own federal judges exposed and vulnerable to violence than open up investigations that might politically damage or embarrass the ruling administration's base. When you watch this entire 6-minute sequence play out, look past the procedural mechanics of the Senate Judiciary Room. This is a profound, deeply chilling window into an institutional crisis where the basic safety of the American judiciary has been compromised by partisan panic. It shows an elite legal panel completely paralyzed by their executive handlers on one hand, while on the other hand, an executive-controlled law enforcement apparatus actively drops the ball on basic police work to protect political allies, leaving the entire judicial branch hanging in the balance.